Going to call the Balle matter for the motion regarding the attorney's lien. This is case D08392-854D. Counsel, if you state your appearance for the record, please.
Good morning, Your Honor. John Throne, bar number 6145, and Michelle Hauser, bar number 7738. Good morning, Your Honor.
All right. So, previously, you were awarded a judgment for attorney's fees in the amount of $12,000. Is that correct?
Yes, Your Honor.
And has that entire amount been satisfied?
None of it has been satisfied. We still have not gotten a dime of attorney's fees ever on this case.
My understanding, ma'am, was that you indicated they had garnished seized funds from a bank account?
Yes. And she filed this motion, so the constable is going to give her the money back.
Okay.
The whole 300.
Oh,
It should have been exempt.
The
because
constable
it's child
has the money.
support and
Well, look, ma'am, I don't know who told you that. You going to cite some authority to me for that?
no,
Because child support, yeah, it's exempt, but once it goes into a bank account, I'm not sure that it's an asset just like anything else. I don't believe that it's exempt once it hits your bank account. However, counsel, have you guys read that damn Argentina case?
Yes, Your Honor.
All right. I don't see that you have a valid charging lien here. I mean, you've got to absolutely have the right to a retaining lien, but is there a basis upon which you could actually claim a charging lien?
Yes, we complied with the lien statute.
No.
And she did not oppose it, and no, she is.
Well-
she also, quite frankly,
Did she
made a
consent
false
to?
statement to
Did
the
she
bar.
consent to your obtaining a lien?
no, Your Honor, I didn't even get to
Yes,
come
our
here.
fee agreement consents to a lien.
And furthermore,
Well-
Your Honor, she didn't. She was properly served in our motion.
I know all that, but it's a case. It's just the Supreme Court's just come out.
I know.
And it tells me that you have to have a charging lien. And Amjur and all the others tell me a charging lien can't be based on child support or alimony. So I'm not sure. I mean, there's a property settlement issue there that maybe you have the right to a lien on.
Your Honor,
But
can I say something, please?
go ahead.
When I retained Miss Throne, I didn't have an attorney at the
Look,
time. I was
no,
told
okay,
if
that-
I get one, I would receive attorney's fees.
Right, and
You
I told
offered-
everybody that
Right, you
come to
offered
trial,
Miss-
come to trial, and we'll take care of
Right, you
the
offered
fees.
her a
Okay.
judgment against the defendant. She declined to take it, asked you to take attorney's fees as under advisement. You said you would. Then she withdrew before we came back for you to take that under
Right.
advisement.
Nobody sent
week
you the
later.
briefs.
That is not
So
accurate.
this
Well,
should have never
look,
been
look.
on me. It should have been on the defendant
Look.
in the first place.
Stop. Look, the bottom line is there's a potential there for a lien against property settlement. Okay? And so I'm directing that you're going to have to prepare an order for me, or maybe you got.
We'll prepare the order.
All right. The constable is to return funds seized or garnished from the bank account to the plaintiff. The attorney's lien of $12,000 will remain in full force and effect against any resulting property award, and only against such judgment that she's awarded in the form of property settlement from the defendant.
And Your Honor, when the decree of divorce gets entered, could the court direct and secure it? Because the problem is you have two pro pers. An attorney would know, look, before you transfer it, we got to pay the attorneys because they have these liens. You have two pro pers.
I'm going to allow you to. You're going to prepare this order. You're going to.
Yeah, but then the decree, it's requiring us to.
Well, plus there's also a possibility of collusion between the defendant and the plaintiff to make sure we don't
Counsel-
get paid.
Your Honor, I'm asking that this
Look.
this judgment be set aside on me and put on the defendant. He has not paid $1 in
Ma'am,
attorney's
I understand
fees.
that.
Not
We're gonna-
$1.
Ma'am, I understand that we're going to deal with that, okay? Unfortunately, you haven't been able to find an attorney that's willing to wait until you get through trial. I know it's difficult,
And I
but
can't
look,
finish this without
the bottom line is I'm bound to the law, and I agree with you. That lien should not be exercised against child support or alimony, and I don't know what to do with that damn case. I don't know what to do with it. But what I'm going to do is your judgment for $12,000 is going to remain. However, the only source that you're going to be able to collect from is going to be property settlement. At this time, seeking my enforcement is going to be from property settlement from the defendant.
Well, and the problem is you've got a catch-22 here. She can't get that finished because she needs an attorney
Well,
to do a
there's
business
a
valuation.
right, and so wait until the end of the trial, and then we'll have the appropriate. We're going to take care of it. All right. There's already a $7,500 judgment from him in favor of Neil Mullins,
Right, which
and
he
at the
never paid.
I understand, and at the end of the trial, there's going to be a $12,000 judgment from him to you guys.
You set that at a some certain to be paid, and it still wasn't done. I mean, he.
Ma'am, you're not. We're done, okay? At the end of the trial, there's going to be a $12,000 judgment if that's, and I'm sure there's going to be enough property settlement, and that's going to be your judgment. It's going to be a judgment against him. It's kind of screwy, but whatever. That's the way it's going to be dealt with. All right. I guess that your judgment against her is going to be assigned, or
You'll take care of it in trial. You'll have to.
yeah, I'm gonna take care of it that way because that's until I get somebody to tell me how to deal with these damn judgments in family court cases where we got stuff that you can't touch and stuff that you possibly can.
Well, and this is not an easy case where you have.
Well,
something
counsel, I
valid.
mean the problem is you take a case. I tell you I'm gonna give you fees. I'm not a lying backstabber.
I have a 3-year-old
But-
to support, Your Honor. I
Yeah,
can't
we
work for
can't.
free
This case is too complicated to wait till.
to get nothing.
I agree.
So, I mean, we'll take that, and then also, I mean, when
Well,
she does
then,
get a property,
but
I mean, if she gets a
counsel,
property
look. The
settlement-
bottom line is, in your documents, you say we saw this that there was going to be fees. I told you I would take the matter under advisement. You never gave me a brief. You guys,
Yes, we did. I'm sorry, Your Honor, but we did.
It's file stamped, copied. It's in the court record, file stamped, copied.
all right, and then you withdrew. I mean, I get.
Yeah.
What am I supposed to
It is
do?
okay. We understood that, but it was file stamped. You ordered us to provide a copy of our billing
All
statement.
right.
It was on
So
5/1/09.
anyway, for purposes of this, your judgment against the plaintiff is. Your judgment against the plaintiff is set aside. I'm gonna, at this point in time, the $300 needs to be returned. I understand there's an issue of adjudication of a $12,000 lien, and in as far as that would be applied only to property settlement, that will be granted.
Your Honor, can we request not to set it aside against her? Hold both of them accountable, because at the end of the day, if she does get property, let's say she gets some value from the business,
Yes,
she's
sir.
going to have property that she'll have.
I'm gonna
an
sue
effect-
you guys.
That's okay.
Okay? I mean, that's where we're going, and
That's fine.
somebody else is going to deal with it. And unfortunately, that's the way it's going to happen. I would just as soon set the whole damn thing aside.
Well, I don't think setting
But we have a
aside.
valid judgment. We can't collect against the.
Well,
charge.
not if I set it aside, you don't.
That's why we're asking, don't set it aside, leave it intact. You can also incorporate it and deal with it at the trial issue. But she is going to get assets. It's just a matter of what. If you're holding her unaccountable for any payments.
She
leave it
may.
intact.
She hasn't. There's nothing I can lean yet. So look,
I know, that's
yeah,
what I'm
look.
saying. Leave it
At this
intact until the decree's
no.
entered and she'll have
At this
property.
point in time, it's I'm setting it aside. It's moot. There is no judgment. You have an inchoate lien, but you can't perfect it. I can't.
I'd rather just have the judgment and let
Well,
us
I know
that
you
we're
would, but I
down.
can't give you a judgment against an asset that doesn't exist,
We're
can
not
I?
asking for you to just leave the
But
judgment
she's
in
going to have to
place.
go to work someday, and then I could garnish her wages.
That's what
she owes
we're
us
saying,
money,
just-
Your Honor.
We're
Not on this lien. Okay, judgment set aside, the lien's out. That's it. I mean, that's the easiest way for me to deal with it.
Can we get findings of facts because it's an appealable
Yeah,
issue now?
the findings of fact are that these: that the motion was filed requesting attorney's fees reduced to judgment and a lien. The court finds that at the present time there was no that the only potential charging lien that could be claimed would have been for property settlement, that no judgment had been obtained at the time, and therefore the lien and I'm going to take the matter under advisement. I'll write up my own order. Thanks.
Thank you, Your Honor.
All right. Good luck.
The other issue she requested in there, and you need to explain to her, is that we have a retaining lien. She can't have her file without.
Right.
I asked
security.
that Neil Mullins file, though, be returned to me. That is my property. That wasn't part of her. She was supposed to make
Look.
copies of that.
Neil Mullins isn't here.
No, but is it she? In
Ma'am,
that file were
stop. We're
original
done. I'm going to
documents.
issue a
I
written.
don't
I'm
have
going to
the
issue a
copies.
written order based on what you filed. Go. Thank you.
Thank you, Your Honor.
All right. I'm going to call the other case for trial. You guys are going to wait.
Okay.
You'll probably go start in an hour.